so much, sir, for being here in a very short notice of time. So thank you so much. It really means a lot. We also know that you have a lot of experience on what you do, and there is a we know that you have chosen this topic because we all know that we have no idea about what all India Services Act means. Even when you try to share that I am going to deliver a topic on India All India Services Act, I only do the services cases. I was like, what is that? I don't know, because I am a junior, I have no idea about all the acts and all the laws. So since aapka was bolna that only you just said the services that it made me curious about what is it all about. So this is what our platform provides us. Maybe even helps us also. So thank you so much for joining us today in a very short notice. So the stage is all yours. Kindly.
My pleasure. My pleasure. Thank you very much.
Thank you, sir.
All India Services Act has actually come in force in 1951.
Mhm.
But at that point of time, as all of you know, that Constitution was enforced in 1950. But at that point of time, when in 1951 this act was enforced and promulgated by Act of Parliament, and at that time this cadre, All India Services cadre, was already existing. It was in existence. People were already appointed in this cadre. There were people holding the posts which we call IAS posts and IPS posts. And at that point of time in 1950, government had framed rules for governing those two services. But before that, appointments were made in this cadre in 1948. Now, when in 1947, India became a country, at that point of time also this cadre was also already existing. People were holding posts in IPS cadre and IAS cadre. But in any case, 1951 All India Services Act was enforced. And till then, there was a provision made in the Constitution of India, that is Article 312, where under this service was protected. And the rules which were governing their services were also kept in force. But before that, everybody is required to know when actually this service came into existence, because that is very important. And what is this service? Actually, giving a background is very important. Actually, when India was governed by East India Company, East India Company was ruling India. At that point of time, the central services, those were called ICS, Indian Central Services officers, were being appointed by directors of East India Company. They were not making any kind of selection for appointing such officers at that point of time. And those officers were being appointed uh, at England, and English people were being appointed against those posts and were being sent to India and were holding those posts at that point of time. Then in 1853, there was a change. In 1853, the government of England decided to hold selection for these posts. And when in 1858, when East India Company was removed from holding the this governance of the India, then in 1861 rules were framed at that point of time. In 1861, this service was actually created. That was being called as ICS service. And in that ICS service, for the first time, the Indians were made eligible for completing that process. Till then, no selection process was being made. and appointments were being made by directors of the East India Company. Then, when government of England took over the governance of the India directly, then at that time in 1861, in terms of those rules, two cadres were created, two classes in terms of those rules. One is covenant, covenant services, non-covenant services. One class, that is upper class of the officers, was being appointed by selection, but only people from England were eligible for those posts. Then second class was also created in that cadre, and in that cadre, Indians were also permitted to complete the process, and they had been made eligible for completing that process. So that is for the first time in 1861 that Indians were made eligible to complete the process of selection for these posts, those second class of the posts under those rules. This is one aspect which is very important. Then for the first time, first Indian who completed this process of selection and became ICS officer was brother of Rabindranath Tagore. He got selected in 1864 for the first time. That was the first Indian who got selected to this post. Then after that, gradually the rules were changed, and in 1919, Government of India Act came in force, and under that, the Indians were made eligible for completing the process of selection for these posts in entirety. And finally, such services continued, and such services were called ICS services. ICS services. So in those services, the people from England and Indians were jointly holding these posts in India and were governing the Indian territory at that point of time up to 1947. Then after 1947, when independence was declared, then in after 47, it is for the first time that in 1948, this cadre was created. In 1948, who were again called as ICS officers. ICS officers. And at that time, only two cadres were there, two categories. That is IPS officers, that is police officers, and IS officers, that is administrative officers. And in terms of this All India Services 1951 Act, these two services were governed by this act. There was no other service governed by this All India Services Act of 1951. This is the background about this service. That is IPS and IAS. Only these two classes of services were governed by this act. Then afterwards, IFS, Indian Forest Service, was also incorporated in it by making amendment to Indian All India Services Act. That is, I think that happened in 1963, and IFS cadre was also included it in terms of Section 2A. Though in amendment was made in Section 2A that many other services, that is Indian Engineering Service, health and medical education service, that also can be included by making a by issuing a notification by Government of India. But those services were not incorporated in it at that point of time. Only Indian Forest Service was included in it. So All India Services Act governs actually three services. That is IAS, Indian Administrative Service, IPS, Indian Police Service, and IFS, Indian Forest Service. These services are governed by this All India Services Act. Then after that, the government is given power, central government is given power to include other services also under this act. But no services are included under this act. by the government, those central services are also created under different rules, just like foreign services. Indian foreign services cadre is also created by the government of India, but that cadre is created in 1954. That was not in existence at that point of time. That is afterwards created, but that is not brought under the purview of Indian All India Services Act, not brought under that. And simultaneously and gradually, right from that time till date, there are till date 24 central services in existence, which are created by the government of India from time to time. But under this act, All India Services Act, only three services are governed. Only three services, as I said just now. Now, after that, what is important is that how selection and appointment to these posts is being made by the government, and what is this cadre. Let us first talk of IAS, Indian Administrative Service, because that is the first category of posts which comes under the purview of this act. IAS cadre is a cadre created by the central government who perform duties, work in entire India. I will explain like this. An IAS officer is required to perform duties anywhere in the country. Under three categories, they can be appointed. One, one is direct recruitment is made. An officer can be appointed in state cadre. In state cadre, an officer can be appointed in central cadre, and an officer can be appointed to IAS cadre by promotion. But by promotion, the quota is created after 1954. And in J&K state, at that point of time, it was created after 1958. Up to 1958, it was not created. This cadre was not created because in this Article 312, the amendment was made in 1958, and till then, the J&K was not included. State definition of state in 312 was not included in that article of the Constitution. So only after 1958, this cadre was created in J&K state, and till then it didn't exist. Now, officers from central government, IAS officer is actually an officer whose employer is actually central government. Now, if he belongs to a state cadre, belonging to state cadre means he has to work in that state, but as an officer of the central government, whose employer is central government, but he is required to work in a particular state, and he is being given that state cadre. An officer at the time of appointment is being selected in a particular state cadre. There is no state, only one state cadre. There is joint cadre also. Joint cadre comprises of many states. There can be one cadre of two states, three states, or union territories. There can be one cadre. That is called joint cadre. Joint cadre. Those officers are being transferred in those states by the central government at the discretion of the central government, but that cadre is called one cadre. Though those officers work in those states or union territories, which is called as a joint cadre. Then there is another cadre, which is central cadre. Officers who are being appointed in central cadre directly, but those officers are also being deputed by the central government to any state who are being sent on deputation. Then simultaneously, an officer of a state cadre is also being deputed to any other service of central cadre or central service or any other company or government company or corporation owned by the government. So an officer is required to serve anywhere in India by this way, practically, when he is sent on deputation, and otherwise he is required to serve in the state or the joint cadre which is allotted to him at the time of recruitment. Then second method of recruitment to these posts is by promotion of state services officers. State services officers are promoted, rather they are being called inducted to IAS cadre. But there is a limitation to that extent. Only 33% of the posts can be filled by promotion of state civil services cadre officers to IAS induction cadre. And that is the second method of recruitment. For that purpose, rules were framed by the central government in the year 1954. And in terms of those rules, the officers of every state state civil services, just in our state, it is called Jammu and Kashmir Administrative Service, KS officer posts. KS officers are being inducted in IAS cadre as per vacancy position, as per vacancies which are being ascertained and ascertained by the central government and state. And then up to the extent of 33% of the posts, such officers are being inducted by promotion to IAS cadre. That is second method of making induction to IAS cadre. Therefore, the appointments to these posts are being made by direct recruitment and by promotion. Of state cadre services, direct recruitment, anybody who is eligible in terms of rules. Now, so far as direct recruitment is concerned, it is being made by Union Public Service Commission by conducting a combined examination. But that examination is governed by the examination rules which are being followed by Union Public Service Commission. Under those examination rules, the appointments are being made to 24 central services, which includes Indian Forest Service, which includes Indian Revenue Service, which includes the services in railways, which includes services in taxation department, finance department, and many other departments, even in traffic police of railway department, such and account services of central government, 24 services in total. In terms of that combined examination, where under a combined select list is being prepared and appointments are being made by direct recruitment to those posts. But in that case, the candidates who apply for those posts in terms of those UPSC examination rules, they are required to give their consent. They are required to give preference in their application forms. Otherwise, there will be a problem. If one applies for IAS post, question is, can he be appointed against IPS post, or can he be appointed against IRS post? Is it possible? Therefore, they are required to give preferences in order of sequence as per their choice, and as per that preference, the appointments to different services are being made by central government on the recommendations of Union Public Service Commission. The Union Public Service Commission prepares the select list after conducting firstly a preliminary examination, and when preliminary examination is conducted, then candidates are being shortlisted. After shortlisting the candidates, at the time of conducting main examination, the selection is being made. In case of preliminary examination, the merit obtained in that examination is not being taken in consideration for making final selection. That is being only conducted for shortlisting the candidates. Then after the main examination is being conducted, the result is being declared, and after that, the candidates are required to give preference about the services after they qualify the main examination. As per those preferences, interviews are being conducted and they are being selected in a particular service. And by this way, the appointment to 24 services is being made by the central government on the recommendations of Union Public Service Commission. But so far as All India Services Act is concerned, under this act, only three services are governed, and appointment to those three services are being made. Though there are different recruitment rules made for other services, and those recruitment rules are being followed after conducting of examination by the Union Public Service Commission. But combined examination is being conducted for making that selection. This is the background about All India Services Act, and the appointment is being made under this act.
So, sir, thank you so much. I think that we'll just open the floor for the participants. If anyone has any kind of questions, they can just unmute their mics and first of all raise their hands. Anyone who wants to ask the question. Anyone who wants to ask the question can raise their hands. Mr. Nazim Khan.
Sir, Assalamualaikum.
Walaikum salam.
It is really pleasure listening to your lecture, and I don't think, sir, anybody will ever dare to ask you any question on this topic. You are an expert in this topic.
It's my pleasure.
But I wish you all the very good health, and
you.
you're an asset to the bar. You're an asset to the bar.
Thank
All the
you
best
very
to you.
much. Thank you. Thank you.
Anyone who wants to ask the question can raise their hands and unmute their mic. Sir, until then, I have a question for you.
Yes.
When I called you before and I asked you, sir, can you please tell me the topic that you can deliver a lecture on? You said services. I usually do the services cases. So can you tell me what inspired you to, to take the services cases and to take that particular field only?
Yes, very, very good question. Actually, when I started practice in lower courts. I was doing civil cases. After that, I shifted to High Court. What I found in these service cases is that one is required to plead the facts which are absolutely truthful, which are given to you by the client relating to his service, and then you make a case as per rules applicable to the facts of that matter, and you contest the case accordingly. So you are always required to work as a lawyer very honestly, and that is the basic reason that I have found that in such cases, in service matters, you are not required to play tricks while working as an advocate, and that is very important. In service matters, facts are always evident from the documents, which need not to be proved by evidence or disproved by evidence. Those documents themselves depict the actual story, whether you are entitled to any relief or not in terms of the rules governing that case. So that is the reason that I have chosen this field, and I have been doing service cases mostly in the High Court.
Until then, I have been asking everyone that if anyone has any queries, they can raise their question. They can raise their hands. And now I really want to ask about. Can you please tell us about civil service rules?
Civil service rules.
Service rules.
No, so far as this act is concerned, All India Services Act, as I told you that All India Services Act governs three services.
Mhm.
and it actually governs IAS officers cadre. For IAS officers, the central government has formulated and framed different rules for those officers. Conduct rules, they have different conduct rules, they have different leave rules, they have different pension rules, they have different CCA rules. They are not governed by general and combined service rules, which are enforced against all other employees of the government, either central government or state government. They have their own rules, and the central government has framed those rules from time to time for these IAS officer cadre posts. Similarly, so far as civil service rules, which you are saying are concerned, every state has its own civil service rules. Just like Jammu and Kashmir, Union Territory, we have our own state service civil rules. Just like we have first rule, which is important, is CCA rules, classification control and appeal rules of 1956. In terms of those rules, you must have seen those rules. In terms of those rules, the employees who serve the state, who are employees of the state government, who are employees of the union territory, are governed by the rules which deal with the seniority, maintaining of seniority, which deal with this disciplinary action to be taken against such employees, etc., etc. Those are rules which govern the state services of the of a state or union territory. Every state and union territory has its own civil service rules. But so far as IS officers are concerned, so far as employees who come under the purview of Indian Services Act, which is our topic here, they have their own different rules. They are not being governed by general rules of the central government also. They have different rules. A number of rules are there which are promulgated and enforced for their services. Those are different. Those are not general rules. Only pay scale, so far as pay scale is concerned and revision of pay scale is concerned, that is being done in terms of combined rules. And that is being done in terms of recommendations of pay commission, pay commissioners from time to time. And in their case also pay is being revised. But rules are different in their case. Similarly, in state cadre employee, in case of state cadre employees, the rules are also different. They are not governed by those rules. That is the difference.
Someone from Codecast has raised their hand. So I think it's Mr. Wasim Shamus. Can you please unmute your mic?
Assalamu alaikum, sir.
Walaikum salam.
Sir, I have question with regard to Article 311 of the Constitution, wherein a large number of people in government employees have been terminated in our Jammu and Kashmir without holding any inquiry or anything. So, if any such case would come to for defense, what should be or what would be our defense to defend those people who have been terminated, removed from service without holding any inquiry? Whereas Article 311, Clause 1, 2, 3 clearly says that if government wants to terminate the service of any government employee, there should have been a prior inquiry. But government employees are being terminated without such inquiry. So if any such client would come to us, what would be our defense to save him?
You see, so far as Article 311 is concerned, Article 311 has given a set procedure and safeguards. Article 311 clearly says that if an employee is to be terminated from service, he cannot be terminated from service unless and until he is not given opportunity of being heard. That means in terms of interpretation given by Supreme Court in various judgments, especially Corona Coroner's case of 1994, that is a constitution bench judgment of Supreme Court. Everybody knows that no employee can be terminated from service unless and until an inquiry is not conducted when an allegation is leveled against him. So that is one important aspect and component of Article 311. Therefore, as per that, if there is an allegation of commission of misconduct by a government employee, every employer or competent authority is required to hold an inquiry. And inquiry is to be conducted in terms of CCA rules. CCA rules give the procedure, how that inquiry is to be conducted. Now, if that is not done, then there is another subclause in Article 311 that if government is satisfied that in the interest of security of state, it is not reasonably practicable to hold an inquiry, then an employee can be terminated from service without conducting an inquiry. But on that issue also, there is a judgment of Supreme Court, rather many judgments of Supreme Court, wherein that provision of law has been interpreted. Supreme Court has interpreted that. Famous judgment is Ashok Kumar's judgment. I think that is of 1995 or 85, something like that, which we have been citing in number of cases where the state government had removed a number of employees under that clause without holding an inquiry, saying that it is not reasonably practicable to hold an inquiry in the interest of security of state. Then judicial review is permissible. You can challenge that also, that it was reasonably practicable or the ground or the reason given in the order is not justified. Then the proposition given in that judgment by Honorable Supreme Court is there. If under that it comes under that purview, then that order can also be questioned by High Court. So you are not debarred from challenging that order in a court of law. You can challenge that order also in a court of law, and judicial review of that order is also permissible. There is no problem in that. We have been filing cases. We have filed number of cases in the past wherein government had, rather governor of the state, then state had terminated a number of employees, and number of judgments were passed by this Honorable High Court, and those termination orders were quashed because Honorable Court did not find that those orders were satisfying the requirement of that Supreme Court judgment. Therefore, you can challenge those orders. There is no problem in that.
Thank you, sir. Thank you very much.
Sir, I also have one question. So, related to All India Services Act, wait, Mr. Farooq Ahmed Paul has raised their hand, so maybe we should kindly unmute your mic, sir.
Assalamu alaikum, sir.
Walaikum assalam.
Sir, I have a question. If entries are made in service book and an employee has availed the benefit or his salary was enhanced due to the entry which was made in his service book. Now later on it comes at the time of retirement that entry, he was not eligible for that entry. And department starts recovering whatever he has gained from that entry. Is that permissible at the time of retirement?
See, actually, the law is that once an employee retires from service, then after his retirement, no inquiry of any kind can be conducted against him. Now, if this is the question, that after retirement of employee, it is found or finger is raised that he has taken salary in excess of what was due to him, then two important issues arise. If that employee has taken excess salary because of commission of a fraud or because of misrepresentation of the facts by that employee, then that fraud can be rectified by the government, because no court can justify the fraud. But in any case, if any employee has taken salary in excess before retirement, that cannot be recovered from him after retirement, because law on that is settled by Supreme Court in Rafi Mashi's case. There is a famous judgment, Rafi Mashi's case, another judgment also. I had also contested a case of agriculture officers in CAT, and we have succeeded in that. Same was the issue, that after retirement, the government is debarred from making any kind of recovery from such employees. So you have every option to contest that in a court of law and show to the court that it cannot be recovered in terms of those settled principles of law.
Sir, what I have seen, number of persons have approached it to me. They say SRO 59 is there in PDD and PHE. Perhaps SRO 59. Department has given them the benefit of, it is the department who has given them the benefit of SRO 59. But unfortunately, now they are deducting the excess salary from their retirement fund.
No, they cannot, government cannot do that in that case. I have also contested some cases on SRO 59. Actually, there are judgments passed by High Court that such employees shall be given the benefit of SRO 59. There is a judgment passed by Honorable Justice Kohli at Jammu in favor of such employees that they shall be given the benefit of that. So if before retirement that benefit is given to them, because it is not a fraud committed by the employees, it is a benefit extended to them by the government itself, that cannot be recovered after the retirement. But in any case,
They,
a case of mine is pending before Supreme Court on this issue. SLP is filed by the state government, that is pending there. I think that judgment, whatever judgment will come in that case, that is govern all those cases of SRO 59.
thank you so much, sir.
My pleasure.
We also had Mr. Hashim.
Hello, sir. Thank you very much for your lecture. Sir, I have a question with regards to an employee. If an employee has served an accident during his employment, and also at that time, if an employee was under suspension, and due to that suspension also, he has suffered because his salary and substance allowance was not being granted, and he had suffered a accident, and will that employee be entitled for any benefits or reliefs?
These are two issues. One is accident, and because of accident he is not able to perform duties after that, that is separate issue. But so far as his suspension is concerned, suspension may be because of some misconduct committed by him. So far as that misconduct is concerned, that is to be inquired into by the government, and government is required to hold an inquiry on that issue. If no inquiry is conducted by the government and employee continues under suspension for a period of three months, now there is a judgment of Supreme Court, and High Court has also passed judgments on that, that no employee can be kept under suspension for more than 3 months. Therefore, after period of 3 months, he is to be reinstated. That is the right in his favor, which you can agitate in the court of law, that he shall be reinstated. So far as accident is concerned, and because of accident he is not able to perform duties, that will be governed by different set of rules. That is a different issue. If he has become disabled, that is a different issue. He is entitled to be given medical leave on that. If he becomes permanently disabled, that is governed by Disability Act. There are rules separately governing that issue. But suspension, so far as suspension is concerned, if no inquiry is conducted within a period of 3 months or up to a period of 3 months, then he is to be reinstated, and you can file a case on that in the court of law.
Thank you, sir.
Miss Urba Nasir has raised their hands. Urba Nasir, you can unmute your mic and ask your question. Urba Nasir, you can unmute your mic and ask your question. Okay, she has written that she is not able to unmute her mic. Until then, Mr. Farooq Khan, he has been asking for a very long time. He needs to ask a question. Kindly unmute your mic, Mr. Farooq Khan. I think he doesn't know how to unmute. So you
He
might
is
be
not
having a
unmuting
question
it.
over there.
He is not
Yes,
unmuting it. He is not
yes,
unmuting it.
yes.
He unmuted his mic.
Yes.
Mr. Farooq Khan,
I
Yes,
please
unmuted.
yes,
ask
yes.
the question kindly.
Farooq sahab.
Assalamu alaikum,
Walaikum
sir.
salam. Walaikum salam. Walaikum salam.
Sir, my small query is whether a court can take cognizance of an offense under Prevention of Corruption Act in respect of a retired employee without obtaining sanction of the government under Prevention of Corruption Act 2006. Can court take cognizance of offense under Prevention of Corruption Act without obtaining or sanction of the government for prosecution?
It is a very delicate issue because conflicting judgments are on this issue. But this issue is very clear. It is one sanction is required to be granted if one is involved under an offense in terms of IPC, Indian Penal Code. Then sanction is required, I think it is 197. But
Yes,
so far as Prevention of Corruption Act is concerned, there were two Prevention of Corruption Acts. One is of central, second is of state. We
yes,
had J&K Prevention Corruption Act, where under sanction for retired employee is also necessary. Because in that act, it is clearly mentioned, the word clearly mentioned is was a government servant, not only is. That word was is interpreted by High Court in a judgment that retired employee also requires and needs sanction to be granted by the government, and without sanction he cannot be prosecuted in terms of that act, that is Act of 2006. But so far as Central Act is concerned, I think under Central Act that word was not existing there. There was a judgment given by Supreme Court on that, and in earlier act also of 1988, that word was not there. So Supreme Court said that sanction for prosecution is not needed in case of a retired government employee. But situation in state, in J&K state, then was different because of that word incorporated in Prevention of Corruption Act, on which a judgment is given by J&K High Court. I think that is by Honorable, elaborated judgment by Honorable Justice G.D. Sharma. So the judgment of Honorable Supreme Court doesn't apply in that case. In that case, if a government employee of state government who was governed by State Act, J&K Prevention of Corruption Act, cannot be prosecuted unless and until sanction for prosecution is not granted by the state government. Difference is this.
thank you, sir.
I think
Sir,
your question is answered.
yeah, thank you, sir. Thank you very much, sir. One more question is that under
Yes.
All India Services Act,
Yes.
as far as I remember, there is for promotion from KS to IAS,
Yes.
in respect of those rules, not only KS officers can be promoted to IAS, but some people who are working in the affairs of the state are also entailed, and there's a 1% quota put reserved for them for promotion to IAS. My simple question is whether the employees working in the government companies are the employees who are working in the affairs of the state, and if so, why are not they given representation in the IAS cadre?
Actually, that is called, we call it technical quota.
Yes, sir. Yes.
That is 15% quota out of total posts which are reserved for promotion of state cadre officers. But in that case, that 15% quota, in that case, requirement is that he must be holding a non-civil service state cadre post. But that post which he is holding must be a gazetted post. Problem in that is that Just like I will explain it like this, that if a person is holding a post in agriculture department, he is holding a gazetted post, but is equal to the post of deputy collector. His post is equal to the post of deputy collector, declared equal to the post of deputy collector, then he becomes eligible under that 15% quota for induction to IAS cadre. But if he is not holding that post, gazetted post, he is holding a different post which is not declared equal to deputy collector post in terms of central rules, then he will not come under the purview of 15% that technical quota. He cannot be made eligible for that. Difference is that in that. But in KS cadre, we have 15%, this 10% reserve quota, wherein we induct these officers of government companies and government corporations also. Because under the state rules, they are eligible. But under IAS rules, that is the embargo kept on that.
Yes. Thank you very much, sir.
Difference is
Thank you.
Sir,
So
we
great.
have an in-call message. It's from Miss Urba Nasir. She has written, Assalamu alaikum. I'm not able to open my microphone. Sir, hope you are doing good. I don't have any questions as I am learning every day from the best. I wanted to express my sincere gratitude for your guidance and mentorship. Your wisdom has been invaluable, and I am truly grateful for the opportunities to learn from you. Wishing you continued good health and success in all your endeavors. So, this is the
thank you
message she
very much.
wanted
Thank
me
you
to
very much.
deliver to you.
Thank you very much.
Yes, sir, I guess. Is there anyone who wants to ask a question? They can raise their hands. Fazan Majid, Mr. Fazan Majid has raised their hand. Kindly unmute your mic.
Sir, this, in my opinion, this discussion would have been incomplete unless we ask you a very important question. And my question to you is, sir, about the concept of service law. What motivated you, being a junior to senior advocate? This question should not have come from me. It should have come from other advocates. But situation compelled me to ask you. I have been your junior, sir, since last 8 years. My question is about the concept of service law. What motivated you to take service litigation? What is the scope of service litigation for young lawyers? Is there any scope for lawyers to pursue service litigation as a career? This is my question to you, because in my opinion, I think this discussion would have been incomplete unless this question would have been asked to you. Service law, concept of
I'm really
service
sorry
litigation.
to interrupt, Mr. Fazan Majid. I'm really sorry to interrupt you, but I have already asked this question to sir before everyone started asking the question. I asked him what inspired you and what
No,
motivated
his
you.
question is
My question is
different.
different.
His question is different. Besides that portion of it is already answered. Question is, so far as High Court wing of Srinagar is concerned, if we see which type of litigation is available in Srinagar wing of High Court and CAD Srinagar,
Mm-hmm.
we find that 90% of the cases are service matters. We have less number of cases from criminal side and less number of cases from arbitration side. So far as Jammu wing is concerned, there is other litigation also in Jammu wing of High Court. But so far as Srinagar wing of the High Court is concerned, 90% of the litigation is service matters. Therefore, any advocate, any young lawyer who starts his career in High Court can start with service law, and he can make a very good career. And I myself am satisfied that youngsters are working hard, youngsters are very capable, youngsters are doing well. I have seen in our High Court, and I feel very happy on seeing them when they argue the matters, and especially civil the service matters. Youngsters doing better, doing very good, and everybody has every chance to make career and earn a lot of money also. There is no problem in that also if you work hard. Only thing in my opinion is that one must work honestly. If you work honestly, two things you will get definitely. One is respect in society, that is very important. Respect in your institution, very important. Then you will be respected by your clients also. That is very important if you work honestly. And working honestly is very important in this uh,
Profession.
profession.
So, is there anyone who wants to ask a question? Because I have one. It is related to, sir, do you think that All India Services Act, how does it maintain a uniformity among the professions that you have said, like like IAS, you just taught the administration department is different, the police department is different. So how will you explain how does this act it maintains the uniformity between the professions?
Actually, there is no question of uniformity.
Mm-hmm.
People, when complete the process of selection under this act, though that selection process is always for 24 services, but every candidate, almost every candidate gives preference for IAS. His first preference is always for IAS, not
Mm-hmm.
even IFS, that is Indian Foreign Service. The reason behind that is that administration of the government is always in the hands of Indian Administrative Service cadre officers,
Mm-hmm.
because those officers start working in a district, they start to head a district and reach the cabinet secretary position of the central government by promotion. So they are always at the helm of affairs of administering the state, so because of that reason everybody gives first choice to ias. And it is not actually, if we see object and if we see background, it is not actually a position which one wants to have for earning money. It is a position which one wants to have for developing the country, for promoting the promoting the youth, for promoting the downtrodden people who are facing number of problems. And if you have worth, you have capability, you can do a lot while working as IAS officer of the country. So object of joining this service is not earning money. Object of joining this service is serving the country. Serving the
Mm-hmm.
country, therefore everybody wants to become IAS officer. That is always first choice. Then second choice is IPS, Indian Police
So,
Service. IPS is also plays very important role. If there is peace in the country, there is peace in a state, peace in a union territory, then people are happy. That is prime consideration of every human being. Then only people are happy. If there is no peace, people are not happy. So IPS officers have very important role to play for developing a country. That is why the second preference is being given by the candidates to IPS. Then other services. In other services also one can play a role, one can work hard in planning department, officers in planning department. They have vital role for developing the economy of the country. So, but they are not at the helm of administration. They are not governing the administration. Though they are developing the country, they are formulating the policies. So that is a different job they are doing. Just like scientists, we see scientists do a lot, but they are not doing administration. They are not at the helm of administration. That is the difference. Everybody prefers IAS. So we cannot equate these posts.
mm-hmm.
We cannot equate, and we cannot say one post is lower in status or cadre than the other post. Difference is that.
I think Mr. Farooq Khan he again raised his hand.
Yes. Let him ask.
So again, this discrimination between two services, it is touching. My next question is touching that. So
Yes.
I got recently a brief from a client wherein there were two officers involved in a criminal case, in a project, in a prevent corruption case. In respect of one officer belongs to state services and another belongs to IS. And when the prosecution sanction was sought from central government, they refused in the same FIR prosecution against the IS officer whereas the state government readily gave the sanction. Do you think that this is a discrimination, and is this discriminatory treatment allowed under the Constitution of under Article 14 of the Constitution of India?
See, in this case, it is not possible to give clear opinion, because reason is that it is always when you have to grant sanction for prosecution, you are required to consider the entire set of material, including allegations, FIR, and the information and evidence collected by the investigating agency against that officer, which is to be taken in consideration for grant of sanction by a particular government, particular competent authority. So if in case of one officer it is found that there is sufficient material for grant of sanction is to be granted. But if in other case it is found that there is no sufficient material, then sanction is not to be granted at all. That is the duty imposed upon the competent authority for considering that matter. So in this case, if there is different material against the IAS officer where sanction is refused, then you cannot say they were similarly situated. But if there is same material, similar material against both the officers, then of course it is discrimination. And you can agitate that in a court of law.
Thank you, sir. Thank you very much. So
So
great of
we'll
you.
be taking the last question for today's session. It's from Mr. Ishtiaq Mir.
Assalamu alaikum, sir.
Walaikum assalam.
Sir, I have a question since this is a service-related lecture, sir. Sir, my question is that can the defense of non-availability of post, if the plea of the respondents is that there was no available post at the time of promotion, can it be the ground for denial of promotion? Because, sir, in every recruitment rules, there are some certain percentage of posts which are leave reserve posts. So can the non-availability of the post be the ground to deny the promotion?
See, what is this consideration for promotion? Prerequisite for consideration for promotion is availability of a post. Of course, that post, if prescribed under the rules in your quota, must be available when you are to be considered for promotion. If that post in terms of rules is not available, then you cannot seek consideration for promotion, because when post is not available, question of consideration doesn't arise. Therefore,
Yes, sir.
that is not the right. Right is right of consideration for promotion only when government needs your position, your holding a post. If government doesn't need that is not available, then you cannot seek it. Then none of your rights is violated.
Yes, sir, I got your point, sir, but my question is slightly different. In every recruitment
Yes,
rules, there is this specific percentage of leave reserve posts. And then what is the fun of keeping these posts? For example, we have 10% or 5% quota for leave reserve posts. And in one case, they have utilized such posts. They have utilized those posts and have given the promotion to the promotees. Now, my question is, if there is leave reserve post and you have already utilized those in other cases, why can't you utilize in my case? That's my specific query, sir.
Actually, leave reserve post is not to be utilized for promotion. It is my opinion. It is my opinion. I had argued a matter in KS seniority case where leave reserve posts were utilized for promotion. I had argued this, that leave reserve post cannot be utilized for making promotion, because leave reserve post is not a duty post. Promotion is to be made to duty post. Leave reserve
Yes, sir.
post
Yes,
is
sir.
not a duty post. Is not a
Yes, sir.
duty post.
Yes,
So
sir. Now my
that is
question.
my opinion. But if in
Yes.
one case it is done, you can agitate before court of law that in one case it is not done and in my case it is ignored. Then that is
Yes,
amounts
yes,
to discrimination.
yes, sir. No, I truly got you, sir. But the point here is that I don't seek the functional promotion. I am retired now. I want that post to be utilized just for the purpose of withdrawal of those service benefits. Only for that purpose, withdrawal of my service benefits. I don't need any functional promotion.
If you are discriminated, one is given the benefit, you are not given that, you can agitate in a court of law. You can file a case on that.
Yes, sir. I don't want any functional promotion. I just want my service benefits which were due to me.
I got
Not
it. I got it.
Yes, sir. Yes, sir.
Yeah.
So with that,
Thank you, sir. Thank you so much, sir. Thank you so much.
My pleasure. My pleasure.
time has flown by. It was an amazing lecture, sir. There is nothing compared to what you just did today. So thank you so much for being here. We can truly see what a seasoned expert you are in the legal realm. So thank you so much for being here.
My
You
pleasure.
were
My pleasure.
Yes, sir. It was like an you had the ocean of wisdom in you, and there were many people. I swear, we get the questions, but we do not get a lot of questions and the queries. And the queries we had today was amazing. It was a shocker to us. So thank you so much for being with us today, with in a very short notice of time. It was really an honor to be hosting you, to be there with you. It was a pleasure to my ears to be hearing from you. And thank you so much for being here. And
Thank you very much.
And
I thank you on behalf of the Codecast team. Thank you so much, sir. It was an amazing lecture, and the way you delivered everything that you delivered today was, a magic. So thank you so much for being here with us, and we hope that if tomorrow or day after tomorrow or a month after this, if we ask you to come back to join us, I hope you will say yes at that time. It will be an
Definitely.
honor and
Definitely.
pleasure to be. It will be a pleasure hosting you. And truly, it was a pleasure hosting you today, sir. Thank you so much. Thank you so much.
Thank you. Thank you very much.
thank you. Allah Hafiz, sir. Thank you.
Allah Hafiz.